Have you ever thought about succession? No, not the show, the law of succession. From 15 to 19 September on my channel, I will be covering content pertaining to Wills Week. I will be going through the Wills Act and making shorts about legal definitions dealing with the law of succession. I will also be looking at testate and interstate succession, as well as the Law Society of South Africa and their role in providing the public with legal services that deal with drawing up a will. Make sure to comment, like, share, and subscribe as my channel tackles Wills Week, 15 to 19 September. What is a will? According to the Wills Act, a will includes a codicil and any other testamentary writing. Simply put, a will is a legal document with instructions on how to deal with the assets and liabilities of an individual who sadly passes away. A will helps in simplifying the administrative process when administering your estate. To avoid legal drama, make sure to use plain and ordinary language. Make sure to review and revise your will as often as you can. The Wills Act states that any person 16 years or older can draw up a will. When drawing up a will, important information must be included, such as your full names, if you're married, who you nominated as an executor, your properties, how your children are to be provided for if you have any children, and lastly, the dates and your signature. When nominating an executor, be sure to first talk to them. An executor is responsible for the administration of the estate of he who is no longer with us. Simply put, an executor is tasked with winding up the estate. Where you have property, explain in your will how you want your property dealt with, who will inherit what. Which property will your heirs inherit? To avoid confusion, provide full names of your heirs and which property each heir will inherit. If you have children, it is incredibly important to explain in your will how they are to be provided for. Nominating a guardian is a good place to start. Be very mindful of who you want your children's guardian to be, because the guardian will be looking after your children and living with your children. Creating a trust and having a trustee will protect your children's money. It would be a good idea that the guardian and trustee are not the same person. Section 2 of the Wills Act lays out formalities that are necessary when making a will. The testator signs the will. Remember, the testator is he who makes a will, while the testatrix is she who makes a will. When signing a will, there are to be 2 competent witnesses present according to Section 2A3 of the Wills Act. It is advisable the testator sign every page of a will. Section 5 of the Wills Act explicitly states that a witness can't benefit from a will that they were present for when said will was signed. Furthermore, Section 6 of the Wills Act states a witness can't be nominated as an executor. If a witness is nominated, the nomination is null and void. Keep all important documents safe. Your will, deeds to your properties, ID copies, and your children's birth certificates. Keep these important documents in a file and make sure your executor is aware of the file and where you keep it.